Oh, good.
Oh, most definitely, but I think they may be able to solve your problem beyond that. I could be wrong.
That'd be asking way too much. And it's a Monday, Judge, remember, and it's raining.
Oh, that's what we do in the 187th. We always meet demands.
Oh, you could just push dismiss on your keyboard?
That's not a fun.
I know this is not ideal, but.
Nice old man. Does that help?
Yes.
Okay. For the little bit I bet him. Seems to be a nice guy.
Yes, that would be great.
Here, I'll take a look at it. I'm probably gonna head back here.
Well, I'm sorry if I interfered with him, Matt.
Oh, no.
Can you talk to that nice judge there? What I got here is a reduction of
So
fine.
sorry. So Queen is in trial. He might be right now, so I can take a look.
Okay,
I'll just go ahead and.
I gotta go to another courtroom. Can I come back and tell me what?
Yeah, I'll be in the back room, just.
At
Back
9.
room?
Yeah, they're about to do closing.
Okay,
So,
so
yeah.
I leave the judge alone then too. Okay.
Here, actually, I'll follow you out that way so I can take.
Yes.
Oh,
Thank you, Judge.
you're welcome. I will not. All right, will do.
Like that way.
ASAP. Bye-bye.
Exactly. That's why I'm kind of avoiding that subject because it's not.
That's the money for me. Okay, let me go make my rounds and I'll be right back.
Okay, thank you.
Let me let's see. I have it on an external drive. No. I can drop it right onto your computer.
I left my computer in my office. I'm gonna have to leave with some shit.
Okay.
Tell me, is this our stuff?
No, that's for
The
family violence thing.
What I'd like to do is some cool stuff.
You need 20 seconds?
Are you here for your court?
Oh, yeah, it is.
Have you moved that?
That's why. And I'm gonna have to send another email because at the jail at South Tower, it flooded. And so my understanding is the carpet over there keeps getting wet. And then they say, oh, it's gonna be fine. And so now this is probably the 6th or 7th time it's been wet.
No, sir, it's my partner and I taking the entire card. You didn't realize that. So,
All right, everyone, I'm going to call the docket. When I call the docket, you need to let me know you are here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. We are in the middle of the jury trial, but no worries. You still will have your jury trial today. Judge Nahara will do jury selection and then this trial will be concluded and we will start with testimony for your case on Tuesday. Richard Almaraz. Thank you. Jeremy Michael Tapia. Jamaria Simmons. In custody, we have Eliseo Perez Rodriguez, Brandon Sierra, John Stephen Meyer.
Judge, he's present and we're ready on the 24 case.
Daniel Hernandez, Guadalupe Espinoza, April Rodriguez, David Gerwitz. Oh, thank you. Amethyst Salas. In custody is Christopher Rodriguez. Luis, you're gonna have to help me with that last name. Gijon Hernandez. See, when you need help, you need to ask for it. Otherwise, how will people know? He's in custody. Michael Vasquez. Jorge Sandoval is in custody. Arnulfo Cervantes, custody. Juan Arambula. Thank you. Carl Edward Jones. Kevin Jones. Jarius Logan. Jamara Simmons. Octavia Day. And custody is Joe Vasquez. At 11, Jimmy Barrientos, Jasmine Gallegos, Tiffany Sperlin, Richard Reyes, Katrina Ruiz, custody. Thank you. Rudolph Montoya. Oh, she's on bond. Okay. Rudolph Montoya. Ricardo Ramirez. And David Duenas. Is there anyone who came in later? Your name was not called. Yes. April Rodriguez. All right, anyone else? All right, as stated, we're starting jury trial at 9 a.m., which we're waiting for 2 more jurors. So both attorneys will be doing closing arguments. Your phone needs to be on silent. Don't put it on vibrate. Don't mistake. And is it on vibrate? Is it not? Because when attorneys are doing their closing arguments, I like to say they're in the zone. And when something like that happens, that may throw off their focus, and nobody wants their focus thrown off. So look at your phones. Make sure they're on silent. And for those of you who are here for jury trial, your jury selection is going to be at 1, and it's going to be right next door. All right, everyone, these are the rules. Criminal Trial Division is there. They'll probably confer with you outside. Family violence is going to be here. They'll probably confer with you outside. If you have an inmate, your inmate will be called up after we do closing arguments. If you need an interpreter, by what do I mean by you need an interpreter? Your person wishes to speak to the court in a language other than English. You need to let the clerk or the coordinator know that your person needs an interpreter. Do not approach the court until you have conferred with the state and conferred with your client. And if your client is in custody, yes, your client needs to be brought out. And sir, who are you? All right, everyone. We are going to bring the jury out, and if you all have time to confer, you may confer outside in the hallway. Good morning. How's it going? Do you still have the joy of Hawaii? Mhm.
When I looked outside, it was my picture.
Ah.
I'm still there.
Yeah. Okay. All right, now put on here, he's excused. Oh, yes, it does say on there, excused. Thank you.
That's part of it. Good luck, guys.
Thank you.
And State Defense, did you all have a chance to review the jury charge?
I know that Ally took a quick look. I don't believe there was any objection, Your Honor.
All right, so we're going to go on the record. Court is calling 2023 CR 2677, State of Texas versus David Solomon Duenas. Could I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Raymond Martinez for Mr. Duenas.
And are you Mr. Duenas? All right, have both parties had a chance to review the jury charge, state,
Yes, Your Honor.
defense?
Yes, Your Honor.
Any objections to the jury charge, state,
Nothing from the state, Your Honor.
defense?
Zero.
All right, you may be seated.
Thank you, Your Honor.
And we can go off the record. So my understanding from Friday, 20 minutes each side, is that correct?
I may push that boundary.
Oh, we don't push boundaries here. Y'all agreed to 20 minutes. I'm sure you all will get it done in 20 minutes.
Court suggestion.
Oh, and everybody agreed. So 20 minutes. So 5, and let you know when 5 is remaining. All
And
right.
Judge Ally should be walking in any minute. It's my understanding the arms for the parking garage were stuck in the closed position for quite some time.
Oh,
So there
that
was
has
a lot
happened to
of-
me on the weekends all the time when I'm here and I'm trying to leave.
He is running over here.
Oh, tell her don't run.
Well,
That's
she
how
might do it.
accidents happen.
That's true. Yes, Your Honor.
Oh, thank you. Diane.
No, they're not. Yeah. Are you going to 14 by any chance? Have you told Jake that we're in here? Please. Apologize for my this, Judge.
Oh, no, no problem. I've been in the garage before where the arm would not come down.
Yeah, finally
Well,
someone
come up.
came and let us all in instead of making us swipe our cards a million times.
Well, you know where the problem's going to come, right? When you
Someone-
try to go out, it's going to say that you're not in the garage.
Oh, yeah, but that's an afternoon.
Yeah. Oh, so you know what? I'm going to make sure I walk past and see all the lights. You guys are going to be lit up like Christmas lights.
That's excellent. Absolutely.
Going.
You never said that, right? Yeah, no, he never said that. Yeah, absolutely. Oh, yeah, that's part of what we're getting.
Yes.
Ricardo Ramirez. April Rodriguez. Even if it wasn't immediate damage. Jeremy Tapia. Michael Vasquez. Say that. Start. Away from the wall. Away from the wall. Do not fall asleep. So you will not fall asleep. Oh.
Anyone came in late? Okay. Obviously, that guy sitting right there is late. Because he's on the first row. What's your name, sir? What's the name of the guy sitting next to us? Ah, okay.
I'm just here, somebody else.
All right, you're on the wrong row. Ray. If you can come forward for a moment. No, that's fine. We're good. On that, what are you asking for?
Oh.
How much? Mhm. Okay. All right, I'll put it at 3,000. Oh, and you have a blank space for me to appoint somebody.
Well, I want to make sure the guy.
All right, if you'll do that. Well, what I'll do is I'm just going to cross out this part where it says somebody is appointed, and that will just give you, this is the amount. Okay. And if you need a copy, they'll give it to you in the back. Who's the prosecutor on Darren Doe's? Is that criminal trial division?
It's family violence. It's gonna be Anna, Your Honor.
Okay.
Yes.
Not really a lesser place, right? I wanna do that.
Yeah. She had.
I don't see this, it's like 9:30, up to last an hour too.
I don't know, saying she needs to be here first. She-
So. Yeah, she said she'll. So I'm like, I feel one. It's like, that's all you don't let that one. Yeah. Judge, may I have
Yes.
I have a compliance hearing with the Mr. that goes set at 11 a.m.
Mhm.
Just, I've had no contact. I believe my appointment is over. We did a plea agreement. She took a probation plea. So I'm no longer attorney of record. It's normal asked me to appear. Because your name still stays on the system even after you do the plea.
Okay.
I just wanted to make the court aware because I have a CPS case that's gonna start at 9:30. It's gonna last all morning. Like authorization to place a child that I can
Okay.
working all weekend, so. If she does appear by some miracle at 11, I'll get over here if I have to.
Okay.
Seriously, she's gonna-
Okay. All right. Thank you.
Yes, sir. And I have any phones? They gave me one for all.
You know what, I can't get it.
Okay.
All right. Thank you. Is everybody here?
No, Your Honor, just listen to me.
Okay. Mhm. Oh, let's bring him forward. Mhm. Okay. Yes.
A little bit of time.
And is there a warrant for him? Is there a warrant for Jimmy Richard Barrientos?
That's.
Hello. Hi, why have you missed all of your appointments with felony drug court? They tried to call you on December 19th, 20th, 21st, 22nd. And they emailed you on December 20th, the 22nd. No, felony drug court. Why did you miss your appointments with felony drug court? Okay, let me ask you this. When you drug tested today, what are the results going to be? And you're going to get drug tested today. Okay. I'm going to want him drug tested today and they can do it at the facility. If that drug test is positive, what's going to end up happening is a motion to revoke is going to be filed. Do you understand? Ms. Abrams. Was he positive for his previous results? Because according to the conditions, it says that if he was positive on the 18th, then he was going to safety. All right, we're gonna see what she says. Okay, all right, I'm gonna want you to go do a UA today. And why are you sleeping in court?
My friends all know that I'm doctor and for 7 years I was sick, I know I will wake up. It's a part.
Okay, that doesn't even make any sense to me. Why are you staying at your friend's house? Yes,
Yeah,
why?
she was in my house. I'm staying out there with my dog.
So she's staying at your house because of your,
She was in my house, dog like that. Simple.
oh, so she won't stay at your house because of your dog. So this is your girlfriend?
Well, and the best friend,
Okay. All right, you're gonna do a drug test today. And you're gonna do it at the facility. If it's positive, a warrant's gonna be issued for your arrest. Do you understand? Ms. Abrams, can we get a drug test for him done today?
Yes, Judge.
And is there anything else that's needed of him?
What did you want to do about the drug court evaluation?
Let's re-refer him to felony drug court. If you miss an appointment with them, then what's going to end up happening is a warrant's going to be issued for your arrest. A warrant should be issued for your arrest right now because you missed your appointments. No,
if I come out dirty, I was gonna go to that.
no. And I want you to do this for me. Stop moving the goalposts on me. At first, I asked you, why did you miss these appointments? Then you tell me you didn't know. And now you're telling me, I thought since I tested negative, I didn't have to do A, B, or C. So this is what I'm telling you right now. You're going to be re-referred back to felony drug court. If you miss one of those appointments with them, a warrant is going to be issued. You're going to take a drug test today. If that drug test comes back positive, a warrant's going to be issued and a motion to revoke is going to be filed. Do you understand? Are we clear on everything? Probation will let you know. Probation, is there anything? All right, thank you.
Find him? That Matthew boy?
And there's no warrant out for him?
No change.
Okay,
Judge, may I approach?
yes.
The DA has no problem with you changing the bond and they're checking with DPS. That's why they need you to work with.
Okay.
But in the meantime.
Oh, it's already been signed.
Can it be sent to the, pretrial?
Well, what they'll do is they'll give you a copy of it in back. And so they'll give you a copy. And they'll put it in the system.
They'll put it in the system so the pretrial officer, if she wants it before she sends it.
Yes, okay.
And I put her name on there. Oh, please. I hate it when women say I need to talk to you. Usually it doesn't turn out good.
Yeah. Ricardo Ramirez,
Yeah. Is this what you think?
Jeremy Tapia. Guadalupe Espinoza. Amethyst Salas. Michael Vasquez. Kevin Jones. Ricardo Ramirez. All right, Deputy Laura, any update?
Mr. One Judge, and, is Adriana, she can call, and one is walking in.
Ah, okay.
Sure.
The rules are not, if some person is going to instruction, the state is no longer instruction, there is evidence that negates the greater offense. But that's not understanding.
That's the only thing on the field. When I finish a brief, I send up a motion to withdraw.
Well, usually on it, it says until it's exhausted, until appeals are exhausted. So do we have a, do we have a ruling yet? All right. Mr. Seelock. Okay, once, yes, once there's a ruling, I will rule on your motion to withdraw. Because you never know, the appellate court may say, oh, we want this from you, or we want an argument from you, even though you don't request an argument. You know, one time I requested an argument, well, I would always request an argument, and they gave it to me. I was like, wow, okay. And before I requested an argument, they were like, no. But then they said, yeah, we'll hear argument. So.
That's the latest one out of this college's Nolan Davis, and it was Jessica Brianna. I did a motion to withdraw.
Okay,
The one that killed her daughter.
I think they're still waiting for that. No, they haven't. But they want your brief right away, but they have not ruled.
Don't get me started. One of my. I'll pass. Yeah, that was for. Now, my friend of
They clearly approved this result.
Well, they've been sending a lot of stuff to the 13th court. Okay, okay.
I never heard that, and I'm also.
Mhm.
I haven't been public.
In years.
It
Yeah.
kind of makes me feel.
Ah,
Okay.
Okay, I'll just put it in the file.
all right, who's the person on the, yes. Who's the female on the first row in the black?
You're on all yours right here.
All right, let's bring him out. All right, we're about to do closing arguments. Everyone needs to make sure your cell phone is off. Attorneys, if you're running to some other court, then do it now. Don't do it during the counsel's closing arguments. Mr. Vega, do you need a seat over here?
No, I was setting up.
Okay.
First row. First row.
Your Honor, he likes sitting by the state.
Mr. Logan, sit in the first row, please.
All right, thank you. Oh, he did. He was on time. Oh, I have him as being on time. Okay.
What? I just like put it out there.
Oh, how long is juvenile gonna last?
So is mine. My roof is leaking.
All right, well, let's play it by ear because we're gonna do these closing arguments and we'll be here in the afternoon. Yes,
It's starting to.
okay,
I drink the rain.
okay. All right, thank you.
Mr. Logan, come back at 1.
Yes. 1:30.
1:30.
Norma, if you can let criminal trial division know that Logan's gonna be a plea and they're coming back at 1:30.
Ready on it?
Yes.
All right, for the jury.
All right, everyone, please be seated. I'm glad you all were able to make it through the heavy rain. All right, what I'm going to do is I'm going to read to you what's called the charge of court, which is the jury charge. Don't worry about memorizing it because a copy will be given back to you when you start your deliberation. Charge of the court. Members of the jury, the defendant, David Solomon Duenas, stands charged by indictment with 2 counts of aggravated assault with a deadly weapon alleged to have been committed on or about the 11th day of September 2022 in Bexar County, Texas. To these charges, the defendant has pleaded not guilty. 1, our law provides that a person commits an assault if the person intentionally, knowingly, or recklessly causes bodily injury to another, or if the person intentionally or knowingly threatens another with imminent bodily injury. A person commits the offense of aggravated assault with a deadly weapon if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. 2, deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 3, a person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of, but consciously disregards, a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 4, the law on self-defense. You are instructed that it is a defense to this prosecution if the conduct of the defendant was justified by law. A person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of an unlawful force. The use of force against another is not justified in response to verbal provocation alone. A person who has a right to be present at the location where the force is used, who has not provoked the person against whom the force is used, and who is not engaged in criminal activity at the time the force is used, is not required to retreat before using force. In determining whether such a person reasonably believed that the use of force was necessary, a finder of fact may not consider whether the actor failed to retreat. A person has a right to defend from apparent danger to the same extent as he would had the danger been real, provided he acted upon a reasonable apprehension of danger as it appeared to him from his standpoint at the time. A person is justified in using deadly force against another, 1, if the person would be justified in using force against the other in the first place, as set out above, and 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. Reasonable belief means a belief that will be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including death. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person who has a right to be present at the location where the deadly force is used, who has not provoked the person against whom the deadly force is used, and who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force. In determining whether such person reasonably believed that the use of deadly force was necessary, a finder of fact may not consider whether the actor failed to retreat. The defendant is not required to prove self-defense. The state must prove beyond a reasonable doubt that the defendant did not act in self-defense. 5, the law of necessity. You're instructed that the conduct of a person is justified if that person reasonably believes the conduct is immediately necessary to avoid imminent harm, and the desirability and urgency of avoiding the harm clearly outweigh, according to ordinary standards of reasonableness, the harm sought to be prevented by the law prescribing the conduct. The term conduct means an act or omission and its accompanying middle state. A reasonable belief means a belief that will be held by an ordinary and prudent person in the same circumstances as the actor. By the term ordinary standards of reasonableness means the standards that an ordinary and prudent person would apply to the circumstances that the actor faced. 6, count 1. You're instructed that the state has abandoned the language in count one of the indictment, charging the defendant with pointing said deadly weapon at and in the direction of the complainant, Duenas Duenas. Now, if you find from the evidence beyond a reasonable doubt that on or about the 11th day of September 2022 in Bexar County, Texas, the defendant, David Solomon Duenas, did use or exhibit a deadly weapon, namely a firearm, and David Solomon Duenas did intentionally, knowingly, or recklessly cause bodily injury to complainant, Duenas Duenas, by striking Duenas Duenas with said deadly weapon, you will next consider whether the defendant acted in self-defense or whether he acted out of necessity, and proceed to paragraph 7 and do not consider the lesser included offense as instructed in paragraph 8. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the charged offense of aggravated assault with the deadly weapon in count 1, skip paragraph 7, and next consider whether the defendant is guilty or not guilty of the lesser included offense of misdemeanor assault as instructed in paragraph 8. 7. Self-defense and necessity as applied to the offense of aggravated assault with a deadly weapon as charged in count 1. Keeping in mind the instructions given in paragraph 4 regarding self-defense, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, you must decide whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the offense of aggravated assault with the deadly weapon as charged in count 1 of the indictment and as instructed in paragraph 6, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1, David Solomon Duenas reasonably believed, as viewed from his standpoint, that Duenas Duenas was using or attempting to use unlawful deadly force against David Solomon Duenas, and 2, David Solomon Duenas reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself against Duenas Duenas's use or attempted use of unlawful deadly force, and 3, David Solomon Duenas' use of deadly force was not in response to verbal provocation alone, then you will acquit the defendant of count 1 and say by your verdict not guilty of the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment and as instructed in paragraph 6. Do not consider any lesser included offense under count 1 as instructed in paragraph 8 and proceed directly to paragraph 10 to consider count 2. However, if you find from the evidence beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment and as instructed in paragraph 6, and you further find from the evidence beyond a reasonable doubt that 1, David Solomon Duenas did not reasonably believe, as viewed from his standpoint, that Duenas Duenas was using or attempting to use unlawful deadly force against David Solomon Duenas, or 2, David Solomon Duenas did not reasonably believe, as viewed from his standpoint, that the use of deadly force and degree of deadly force used was immediately necessary to protect himself against Duenas Duenas's use or attempted use of unlawful deadly force, or 3, David Solomon Duenas's use of deadly force was in response to verbal provocation alone, then you will find against the defendant, David Solomon Duenas, on his justification of self-defense as it applies to count 1, but next consider whether he acted out of necessity. Keeping in mind the instructions given in paragraph 5 regarding necessity, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, you must decide whether the state has proven beyond a reasonable doubt that David Solomon Duenas's conduct was not justified by necessity. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the offense of aggravated assault with a deadly weapon as charged in count 1 in the indictment and as instructed in paragraph 6, but you further find from the evidence that, or you have a reasonable doubt as to whether 1, David Solomon Duenas reasonably believed that such conduct on his part was immediately necessary to avoid imminent harm, namely serious bodily injury, and 2, the desirability and urgency of avoiding the harm of serious bodily injury clearly outweighed according to ordinary standards of reasonableness the harm sought to be prevented by the law prescribing aggravated assault with a deadly weapon, then you will acquit the defendant of count 1 and say by your verdict not guilty of the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment and as instructed in paragraph 6. Do not consider any lesser included offense under count 1 as instructed in paragraph 8 and proceed directly to paragraph 10 to consider count 2. However, if you find from the evidence beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment and as instructed in paragraph 6, and you further find from the evidence beyond a reasonable doubt that 1, David Solomon Duenas did not reasonably believe that such conduct on his part was immediately necessary to avoid imminent harm, namely serious bodily injury, or 2, the desirability and urgency of avoiding the harm of serious bodily injury did not clearly outweigh, according to ordinary standards of reasonableness, the harm sought to be prevented by the law prescribing the offense of aggravated assault with a deadly weapon, then you will find against the defendant on this justification defense of necessity as it applies to count 1 and find the defendant guilty of the offense of aggravated assault with a deadly weapon as alleged in count 1 of the indictment. Skip paragraph 8 and proceed directly to paragraph 10 to consider count 2. 8, lesser included offense of assault in count 1. Now, if you find from the evidence beyond a reasonable doubt that on or about the 11th day of September 2022 in Bexar County, Texas, the defendant, David Solomon Duenas, did intentionally, knowingly, or recklessly cause bodily injury to Danessa Duenas, you will next consider whether the defendant acted in self-defense or whether he acted out of necessity and proceed to paragraph 9. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of assault in count 1. Do not consider paragraph 9 or proceed to paragraph 10 to consider count 2. Nine, self-defense and necessity as applied to the lesser included offense of assault in count 1. Keeping in mind the instructions given in paragraph 4 regarding self-defense. Even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the lesser included offense of assault in count 1, you must consider whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the lesser included offense of assault in count 1 as instructed in paragraph 8, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, David Solomon Duenas reasonably believed, as viewed from his standpoint, that Danessa Duenas was using or attempting to use unlawful force against David Solomon Duenas, and David Solomon Duenas's use of force was not in response to verbal provocation alone, then you will acquit the defendant of the lesser included offense of assault in count 1 and say by your verdict not guilty of the lesser included offense of assault in count 1 and proceed to paragraph 10 to consider count 2. However, if you find from the evidence beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the lesser included offense of assault in count 1 as instructed in paragraph 8, and you further find from the evidence beyond a reasonable doubt that David Solomon Duenas did not reasonably believe, as viewed from his standpoint, that Duenas was using or attempting to use unlawful force against David Solomon Duenas, or David Solomon Duenas's use of force was in response to verbal provocation alone, then you will find against the defendant, David Solomon Duenas, on his justification defense of self-defense as it applies to the lesser included offense of assault, but next consider whether he acted out of necessity. Keeping in mind the instructions given in paragraph 5 regarding necessity, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the lesser included offense of assault in count 1, you must decide whether the state has proven beyond a reasonable doubt that David Solomon Duenas's conduct was not justified by necessity. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the lesser included offense of assault in count 1, and as instructed in paragraph 8, but you further find from the evidence that, or you have a reasonable doubt as to whether 1, David Solomon Duenas reasonably believed that such conduct on his part was immediately necessary to avoid imminent harm, namely bodily injury, and 2, the desirability and urgency of avoiding the harm of bodily injury clearly outweighed, according to ordinary standards of reasonableness, the harm sought to be prevented by the law prescribing assault. Then you will acquit the defendant of the lesser included offense of assault in count 1 and say by your verdict not guilty of the lesser included offense of assault in count 1 and proceed to paragraph 10 to consider count 2. However, if you find from the evidence beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the lesser included offense of assault in count 1 and as instructed in paragraph 8, and you further find from the evidence beyond a reasonable doubt that 1, David Solomon Duenas did not reasonably believe that such conduct on his part was immediately necessary to avoid imminent harm, namely bodily injury, or 2, the desirability and urgency of avoiding the harm of bodily injury did not clearly outweigh, according to the ordinary standards of reasonableness, the harm sought to be prevented by the law prescribing the offense of assault, then you will find against the defendant on this justification defense of necessity as it applies to the lesser included offense of assault in count 1 and find the defendant guilty of the lesser included offense of assault in count 1. 10, count 2. Now, if you find from the evidence beyond a reasonable doubt that on or about the 11th day of September 2022 in Bexar County, Texas, the defendant, David Solomon Duenas, did use or exhibit a deadly weapon, namely a firearm, and David Solomon Duenas did intentionally or knowingly threaten imminent bodily injury to Christian Rodriguez by shooting at Christian Rodriguez with said deadly weapon, you will next consider whether the defendant acted in self-defense or whether he acted out of necessity and proceed to paragraph 11. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the offense of aggravated assault with a deadly weapon as alleged in count 2 of the indictment and do not consider paragraph 11. 11, self-defense and necessity as applied to the offense of aggravated assault with a deadly weapon as charged in count 2. Keeping in mind the instructions given in paragraph 4 regarding self-defense, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment, you must decide whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment and as instructed in paragraph 10, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 4, David Solomon Duenas reasonably believed, as viewed from his standpoint, that Christian Rodriguez was using or attempted to use unlawful deadly force against David Solomon Duenas, and 5, David Solomon Duenas reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself against Christian Rodriguez's use or attempted use of unlawful deadly force. And 6, David Solomon Duenas's use of deadly force was not in response to verbal provocation alone, Then you will acquit the defendant of count 2 and say by your verdict not guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment. However, if you find from the evidence beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment and as instructed in paragraph 10, and you further find from the evidence beyond a reasonable doubt that 1, David Solomon Duenas did not reasonably believe, as viewed from his standpoint, that Christian Rodriguez was using or attempting to use unlawful deadly force against David Solomon Duenas, or 2, David Solomon Duenas did not reasonably believe, as viewed from his standpoint, that the use of deadly force and degree of deadly force used was immediately necessary to protect himself against Christian Rodriguez's use or attempted use of unlawful deadly force, or 3, David Solomon Duenas' use of deadly force was in response to verbal provocation alone, then you will find against the defendant, David Solomon Duenas, on his justification defense of self-defense as it applies to count 2, but next consider whether he acted out of necessity. Keeping in mind the instructions given in paragraph 5 regarding necessity, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment, you must decide whether the state has proven beyond a reasonable doubt that David Solomon Duenas' conduct was not justified by necessity. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment and as instructed in paragraph 10, but you further find from the evidence that, or you have a reasonable doubt as to whether 1, David Solomon Duenas reasonably believed that such conduct on his part was immediately necessary to avoid imminent harm, namely serious bodily injury, and 2, the desirability and urgency of avoiding the harm of serious bodily injury clearly outweighed, according to ordinary standards of reasonableness, the harm sought to be prevented by the law prescribing aggravated assault with a deadly weapon. Then you will acquit the defendant of count 2 and say by your verdict not guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment. However, if you find from the evidence beyond a reasonable doubt that the defendant, David Solomon Duenas, committed the offense of aggravated assault with the deadly weapon as charged in count 2 of the indictment and as instructed in paragraph 10, and you further find from the evidence beyond a reasonable doubt that 1, David Solomon Duenas did not reasonably believe that such conduct on his part was immediately necessary to avoid imminent harm, namely serious bodily injury, or 2, the desirability and urgency of avoiding the harm of serious bodily injury did not clearly outweigh, according to ordinary standards of reasonableness, the harm sought to be prevented by the law prescribing the offense of aggravated assault with a deadly weapon, then you will find against the defendant on this justification defense of necessity as it applies to count 2 and find the defendant guilty of the offense of aggravated assault with a deadly weapon as alleged in count 2 of the indictment. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging services, or any social media platform, internet chat room, blog, or website to include, but not limited to, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not a part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for or otherwise charged with the offense gives rise to no inference of guilt at trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to your jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any questions you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to this case must be written, prepared by the presiding juror, and submitted to the court through the bailiff, Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bear County, Texas, and suitable verdict forms are attached. State, are you prepared to proceed?
We are, Your Honor.
All right, you may proceed.
Thank you, Your Honor. So members of the jury, I'm going to take about 3 to 5 minutes to basically walk through what the law is here, right? Just like Judge says, we have the burden of proof here. So I'll speak for about 3 to 5. You'll hear from defense for their 20, and then Allie will finish out with the rest of our time. Okay. So let's talk about why we're here. Aggravated assault with a deadly weapon. Okay. Within that, let's talk about why we're not here. We're not here to discuss motive, why certain people take certain actions. Okay. You're not going to see the word motive anywhere in the packet that the judge is going to send back with you. Okay. So don't worry about motive. That's not why we're here. We're also not here to litigate civil orders, who picks up when, this, that, or the other. Okay. That has nothing to do with aggravated assault with a deadly weapon. Okay. So within that, you're going to see here again, the judge is going to send this back with you. You're going to see this number 6, count 1. And I really want, it's a huge packet. It's a lot of words, but the word I think you should focus on most is the word striking. Okay. Striking with a weapon. On or about a certain date in Bear County, did the defendant strike Duenas with a weapon causing bodily injury? Okay. And there's a lesser included. Basically what that means is there's an assault without a weapon, but as a quick point, I would just point you to the defendant's own words and the body worn camera. The same body worn camera in here that you're going to be able to take with you back there. Okay. Quote, I hit her in the head with the gun. Quote, I meant to push her face off me. The gun just happened to hit her. Okay. That's why we're focused so much on aggravated assault with a deadly weapon, striking Duenas with said weapon. Okay. That's count 1, aggravated assault with a deadly weapon. Okay. Then you're going to see kind of enumerated at the top, this number 10. And again, huge packet. Let's focus on one word, shooting. Okay. Shooting at Christian, right? So threatens serious bodily injury to Christian, the complainant you heard on the stand, by firing a gun. And again, just as a quick point of reference, you'll be able to look at the body worn camera. Quote, I grabbed my gun out and pointed it at his chest. And the occurrence of the gun shooting is really kind of incontroverted, right? You hear all kinds of accounts of it. You have 911 phone calls. We brought in the experts to talk about the firing of the gun. Okay, so that's a very high level analysis of aggravated assault with a deadly weapon. Count 1, striking. Count 2, shooting. Okay, and as a quick kind of high level primer, again, let's talk about what the defense's theory of the case is, right? Really, 1 and 1, we're not able to make 2 there, right? So you have the quotes I just read from the body worn camera, but there's really nothing in the body worn camera. There's really nothing in the photos. There's really nothing in the 911 phone call. There's really nothing with the gunshot residue. There's really nothing with the kind of ballistics, shell casing testing. There's really nothing in the officer recollections to corroborate this account of what happened that night. Okay, so 1 and 1, we're unfortunately not able to make 2 with respect to that account. But when you consider the state's burden, when you consider the number of accounts that were put forth to prove, again, the very simple striking and shooting, we've got about 10 accounts on the other side that all seem to kind of corroborate each other, right? So the first account is kind of the digital evidence, right? Some photos showing some injury, some body worn camera with the defendant's own statements that night. Kind of account number 2, if you will, is kind of the testing and the experts that came in, right? You heard all that testimony. You'll be able to consider kind of the things they brought in. All of that matches Officer Lopez's account from that night. He was actually able to talk about on the stand what he heard that night from all the individuals. And what he said that night kind of matches exactly what he said on the stand. And that matches what Duenas said that night. You kind of hear in the back of the 911 phone call. And Duenas' account that night kind of matches exactly what Duenas' account was on the stand. And that matches Christian's phone call from that night, which matches Christian's testimony on the stand. And that all kind of matches The neutral third party, the guy that was just sitting in the truck, Charles's 911 phone call that night, and Charles's testimony on the stand. So given all of that evidence, we respectfully are going to request a guilty verdict on counts 1 and 2 of aggravated assault with a deadly weapon. Thank you.
All right, defense.
Thank you, Judge. May it please the court, counsel. Good morning, everybody. I want to start off with some housekeeping things. The judge has already told you that if you have questions, submit it in writing to the court. That was a very long jury charge, and it's convoluted and confusing and everything else. But she can't tell you how to interpret it. She can't tell you what does something mean. All she can tell you is if you have a specific conflict about testimony, jurors start deliberating and one juror says, I think witness A said this. No, they said exactly the opposite. If you give her a very specific question like that, where there's a conflict, you'll get an answer. If you ask any other questions to help you decide the issue, the court's not going to help you. She's not allowed to do that. Make sure that your verdict is unanimous. That means if you don't agree with everybody else, just say so. If you get into a position where you can't reach a unanimous verdict, tell the judge that in a note. Don't just sit back there and go like, what do we do? Those kinds of questions you can send. You just can't ask the judge what things mean, what evidence means, what the effect of the law is on punishment. Can't ask any of those kinds of questions. When a person comes to defend somebody in a case, we're here trying to show to the jury why the state has not proven all the elements beyond a reasonable doubt. That doesn't necessarily mean we defend all their actions. Clearly, David could have acted in a different way that night. He exercised poor judgment in certain regards. If you feel like at some point he put his hands on her in a way that he shouldn't have, and not an aggravated assault, because I don't think they've proven those, but in a simple assault, then the language in the charge says you're allowed to find him guilty of that. Now, it's interesting, the state shows you a picture of her bruise on her arm when he grabs her to keep her from going up the stairs. Well, he's not charged with that, right? So how does that evidence help you? He's not charged with assaulting her in that first confrontation. And why is that? Part of the reason is she's the one that got physical with him first. We seem to be skipping that part, that the one who comes kicking and screaming and causing mayhem is Duenas. We know that consistently throughout the case. And I'm going to talk about that some more. So if you decide there's an assault there, I'm not going to argue that point. In the indictment, there's 3 different ways that he can be convicted of aggravated assault. Pointing the gun at her, Duenas, striking her with the gun, or shooting at Christian. But what happened in this trial on paragraph 5, the judge tells you the state abandoned the first one. What does that mean? They're telling you, never mind that pointing business. That didn't really happen. We're not really sure why we indicted him with that. We literally have no evidence of that. And so we're just going to take it back. Never mind. That should scare you to death. That an officer can investigate a case, all this manpower is addressed to the case. It goes before the grand jury, and he gets charged with something that nobody ever even said that he did. I point that out to you, and I think you should spend a lot of time focusing on that. It's because it's symptomatic of the very poor investigation that was conducted in this case, the very little thought that was put into, what happened. And we all know why that is. You get a call, a gunshot went off. They already know what they're going to do. What did the officer tell David? Stay in your room. When we finish this investigation, we're going to come take you to jail. They hadn't done the investigation yet. They hadn't even spoken to him. But they told him, we're taking you to jail. Why? Because they made up their mind. And he came out in the trial. Oh yeah, we got a little bit ahead of ourselves. We charged him with something he never really did. The grand jury process is set up to make sure that people don't get wrongfully charged with things that they shouldn't be charged with. It didn't work in this case. It didn't even come close. Can you imagine somebody getting charged with something that nobody ever said that they did? Yeah, it happened in this case. So now we're down to only 2 different possibilities of aggravated assault with a deadly weapon. And I'm going to suggest to you, you don't need to spend a lot of time studying that very voluminous jury charge, because the state's own witnesses proved reasonable doubt. The state's own witnesses gave you all of what you needed to find reasonable doubt. Let's start with getting hit on the head with the gun. What does David tell you? And what do we know from this case? That Danessa is aggressive and puts her hands on him from the very get-go. What did the defense witnesses tell you? She's known to do that. Throughout their relationship, she never would hesitate to slap him or hit him if the thought occurred to her to do that, right? And so the hitting on the head with the gun, even though he's not intending to hit her with a gun, he just happens to do that. What the state skipped is that it was in the process of self-defense. This is a classic self-defense case. Somebody hits you, you hit them back to stop you. And why do I say that the state's witnesses prove that? Charles tells you her head goes back, consistent with Danessa's on his back, hitting him from behind, and he punches back at her. He's not trying to hit her with a gun. He's not trying to hurt her with the gun. And if that happened inadvertently, it still doesn't matter because it falls within the four corners of self-defense. One of the things that's in this jury charge that is important that you should be aware of, the state has to prove beyond a reasonable doubt that self-defense does not apply. How do they do that on the issue of him hitting her with a gun? They can't. What are you supposed to do when somebody's on your back and they're slapping and hitting at you? You just let them keep doing that? Do you let them keep doing that because it's a girl and not a guy? No, the law is very clear. You can stop them with self-defense. The state's witnesses, through Christian saying that she fell back off of him, Charles saying her head went back when he hit her, David saying, I punched back at her. They're all consistent with each other. That striking, whether it's with the gun or without the gun, was a self-defense. There's no other way to interpret the testimony. The state might argue, well, you can't create a conflict. You can't start a fight or start a ruckus and then raise self-defense, right? So let's say, let's change the facts of the case and David did something to start an argument or a fight. And then he said, oh, but I was defending myself. No. We all know how this started. This started with Danessa insisting on getting her way, right? And I'm going to talk a little bit about whether she was intoxicated or not, because I think it plays into this issue. And she goes there and we all know that if he doesn't stand there at the bottom of the stairs, she's going all the way to the third floor and she's banging on that door. She's going to wake everybody up because she wants to take her child, right? She could have just as easily said, oh, you're not going to let me go upstairs? Go call the police. They're going to come and they're going to let me go upstairs and get my child. She didn't do that because she'd been drinking. We know that. And I'm going to talk about that some more. And she insisted. David didn't want this fight in front of the kids. He didn't want his wife, who was a week away from delivering her child, to experience all that. He wanted to stop it there. But she wasn't going to let that happen. So no, he doesn't create this conflict. He doesn't create this fight. He doesn't create this mess. So self-defense does apply. Police officer wants to say, well, I don't see any injuries on him to suggest that that happened. The crime scene person told you they took over 120 pictures in this case, but only 2 pictures to the back of his head. And that's a critical issue in this case. Was he defending himself? Was he injured? And what does the officer say? Oh, no, I don't see it. Look at the pictures. There's only 2, but there's one that's very clear. He's got all kinds of redness right around his ear and behind his ear, consistent with somebody hitting or punching. We should have had at least, out of those 120 pictures, 5 or 6. Why didn't they do that? Because they'd already made up their mind. The gun went off. He's going to jail, aggravated assault. This is a simple case. I don't even need to talk to him to make that decision. I've already decided it. Why would an officer tell him he's going to jail before they started the investigation? Because they'd already made a decision. I'd ask you to look at his video. His testimony on the day of the event is calm and it's consistent with what he's testified to on the trial, and it's logical, right? We all know how these child custody changes happen. People are not together anymore. They try to get along, but at some point they don't, and sometimes it gets ugly. And that's what was happening here. He had no intention of causing any harm to anybody. As a matter of fact, he wanted it to stop. He wanted her just to leave. Let me talk about being under the influence, and why do I keep making a harp on that? Because it alters people's behaviors, right? You see in the text messages that were admitted into evidence that the communications were cordial. Hey, are you at home? No, I'm not at home. All right, I'll get with you later. But how does it change? After she's been 2 hours at the bar and they're running their tab, right? And he's like, no, just get him tomorrow. And she goes, no, I don't give you shit when you come late for a pick. Whoa, where did that come from? Where did all that cordiality and cooperation go? Well, it went away because she'd consumed alcohol. She doesn't like the fact that she's being rushed. You know, she's trying to spend an evening with her boyfriend watching the football game. And so she comes over there ready for a fight. And he already knows what's coming. He's seen this movie so many times. And so he tries to stop it, right? So we have to consider Vanessa's behaviors in how we get to this position. Counsel wants to tell you, we don't have to prove motive. Of course, they don't have to prove motive. But motive is very important to look into what people are thinking, right? What does David want to happen that night? These kids got to be up at 6 o'clock in the morning to get on the bus. I got to go to work. We're in bed at 9 o'clock. You saw that apartment when they went in there later. It was totally dead quiet. All the kids are asleep. The exact kind of ruckus he didn't want to happen inside his apartment. It happened in the street, but it didn't happen inside the apartment. Her motivation was to get her way. That's the bottom line. And so that has a lot to do with clouding how we look at this case. So 3 ways they can prove him guilty. Number 1, they've already abandoned. Number 2, we know that if that gun hit her in the head, it was inadvertent. And even if it did, self-defense falls squarely on those facts, right? So we're left with number 3. And someone said, well, he shot the gun at him. That's easy enough. Disagree. I think number 3 is the easiest one to look at and show that there's reasonable doubt. And why is that? You saw pictures. The cars are very close to each other. They're fighting between the cars. Christian says on multiple occasions, he's at arm's length away from me. Like he's like right next to me, basically. And he shoots the gun. How does he not hit him? Well, it didn't happen like that, right? It didn't happen like that. And as often happens in these trials, you learn things in the trial that we never heard before. And what did we hear from Christian? As the gun is in his hand, somebody's pulling him from behind, and then the gun goes off. That's a very, very different explanation of what happened than what's in the reports. Very, very different than what the officers heard at the scene. How do we know that he had never said that before, except when he said it on the stand? Because it would have been in the officer's report. I would have questioned that officer endlessly on that point. He's clearly describing an accidental discharge of a gun, but why are you charging him with aggravated assault? The officers may not even have charged him if they'd known that day. But if something happens when you get up here and the pressure and the stress of being under oath and having to be in front of a lot of people, the truth just comes out. That truth makes so much more sense than the version that they wanted to give you, right? David tells you, the only reason I took that thing out is I've got 2 people already on top of me and I'm trying to get them to get away, right? It's consistent with Charles's testimony that Vanessa's on his back. It's consistent with our belief that self-defense applies because she's hitting him. It's when she falls off of him and tumbles over. And what does Christian do? He comes to her aid. What else is he going to do, right? David told you and Christian told you, let's talk. They went over there to talk, right? It got out of hand because Vanessa fell over. Maybe he thought she got hurt. And before you know it, Christian's punching him too. And look at those pictures closely. You can see on David's face, you can see welts under his eyes, consistent with him being punched. And the investigator wants to get on the stand and say, I don't see any injuries. He made up his mind how this case was going to go before he asked David one single question. And he's going to make sure his testimony supports the reports that he wrote and the conclusions he came to. But they can't change what you heard on the stand, folks. What did Mr. Pendleton tell you when we proposed to him the scenario? Well, if he's got the gun in his hand and his hand's on the trigger like you would normally have it, and somebody pulls your arm away, can that cause the gun to discharge? Well, sure it can. How is that not reasonable doubt, folks? They have to prove that he intentionally, knowingly, or recklessly discharged that weapon at Christian. And if anything, the state's witnesses, Christian out of his own mouth, told you that was an accidental discharge. Mr. Pendleton told you that can happen, right? Beyond a reasonable doubt. The allegations of aggravated assault, deadly weapon, they do not exist in this case. There's poor behavior. There's poor judgment. there's immaturity, there's lack of reasonable co-parenting. All of that's there. He's paid the price for all of that. But don't saddle him with felony conviction when the evidence is not there. You heard from David's family, you heard from him that this has taken a tremendous toll. The fact that those two people couldn't get along well enough to handle that situation has caused a tremendous toll. Hasn't seen his child in 18 months and learned just in the midst of the trial that he legally cannot. There's an injustice going on here, folks, a tremendous injustice, and that is a very, very poor handling of this case by the law enforcement. Evidence coming to light that is so critical to the resolution of the case not being learned until trial. You can't let this injustice continue. You must do what the law requires you to do when there's reasonable doubt, and that's to find him not guilty. Thank you.
State.
Judge, may it please report, defense counsel.
September 11th, 2022, David Duenas went looking for a fight, and he found one. He found one when he threw on his chanclas, grabbed a gun, and went to a custody exchange. That's what was important. He was so concerned, he didn't even think to grab his phone, just his gun and his shoes. Don't be distracted by kind of the nonsense in this case. Don't be distracted by the custody, the divorce stuff. That's a civil issue, like Investigator Lopez said on the stand. We're here to make David Duenas accountable for the actions that he took that night that endangered both Danessa and Christian. Now, they want you to say, oh, no, it's clear. It's clear Danessa was the aggressor. No. By David's own words, he started the physical altercation. Danessa was upset. She came to pick up the child 45 minutes late, which she probably thought was fine, since the weekend before, he was 30 minutes late. His own words say that they had had no prior problems. They were co-parenting fine. She was getting along with his pregnant girlfriend. There had been no issues until he showed up late the weekend before. So she probably thought, hey, you know what? 45 minutes late after watching a Cowboys game and having car trouble, that's a fair and reasonable thing for him to let me pick up my child late. But he disagreed because, like an abuser, he wanted his way and he wanted to put all of the blame on Danessa. So Danessa shows up and David wants you to think that, oh, I grabbed my gun, I grabbed my chanclas, I was panicked, I thought she was gonna start stuff, but I wasn't agitated when I got downstairs. Oh no, I was calmly waiting, gun in my pants, just calmly waiting for her. They wouldn't have seen that I was upset. That's not reasonable, folks. Instead, he was mad. Danessa was mad. She asked him, where's the kid? She tries to go up the stairs. And by his own words, he laid hands on her first. He grabbed her hard enough to bruise her, yanked her down by the stairs, and then by her words on the stand and that night, hit her in the back of the head. She assumed it was a gun because it was a sharp pain, and then she later knew that he had a gun. The fight continues. Now, David wants you to think, oh, well, I was just protecting my wife. I was protecting the kids. But what does he do? Does he block Danessa from going up the stairs after that? No, he charges off to a truck that he doesn't even know who's in because, oh, this is how I'm going to settle this. This is how I'm going to make, in his own words, the bitch leave. She's behind him. She's trailing behind him. If she really wanted to cause a ruckus, if she really wanted to grab Diani, she could have gone up the stairs. Because he left and went around the building to where the truck was. She could have run upstairs, woken up the girlfriend, gotten the kid, and left. But what did she do? Danessa ran after him because she knew he had a gun, and she knew that her boyfriend and their boyfriend Charles were sitting there like sitting ducks. So she ran after him to try to stop him. And by her own words, she kept trying to pull him back. And she did admit to hitting him in the head because he had a gun and he'd already hit her with it. That's reasonable. His story, not reasonable. His story is, oh, I walked up to this truck. I see two people that I don't know. And I went, can you get this bitch out of here? I wasn't aggressive. I wasn't upset. Does that make sense? No. What makes sense is their story. Hey, I want to talk to you. That makes sense with the impressions. That makes sense with the mood of everything. They want to make this big deal of, oh, the state, you didn't prove self-defense. We did prove that it wasn't in self-defense because, hey, guess what? If you were going to act in self-defense and you were going to use potential deadly force and you were going to use a weapon, you have to be in imminent fear of serious bodily harm. There was none of that. The most Danessa did was hit him in the head, which she admits to. But he wants to claim that 3 people, he changes it. It goes back and forth. I don't know if you guys noticed, between 2 of them were hitting me to all 3 of them jumped me. You have the photos. You have their photos. If 3 people are wailing on you, you're going to have more than some redness behind the head. They're going to have some marks. You might have scratches. She has longer nails than I do. And I scratch myself on accident all the time. And if she is wailing and wailing, she's going to scratch you. He also changed his story once he got to see the physical evidence of, oh yeah, no, she totally ripped my shirt that night. She ripped my shirt. She was pulling on it. She was aggressive. Then we pulled it out. It's not torn. Oh, I guess I misinterpreted that. Because the thing to keep in mind, folks, is that the only person who got to sit here and watch all of the testimony and hear all of the evidence is David. The same way that he got to sit there for over an hour before investigator Lopez got to the scene to think of a way to make himself the victim and how to put everything on Danessa. Because like his family also said, it's always Danessa's fault. How like an abuser. Because I'm betting if in his own words, oh, it's not assault because I just smacked her with an open hand. Folks, under the law, that is assault. And so maybe he thinks that, oh, it was always unprovoked because I just hit her open hand. And so she wasn't, if she ever hit me back, oh no, that wasn't justified because I never assaulted her. Open hand. That is a man who has never taken responsibility for anything in his life. And he wants to sit here and come up with an excuse and an excuse for every little thing. You heard him on the stand. He couldn't take responsibility for anything. He couldn't admit to doing anything wrong. Everything was on her. He wants you to believe that Danessa was a danger, but has no reason to have thought that. He wants you to believe that he panicked, but by the time he got downstairs, he wasn't agitated. Everything is on her. His story isn't reasonable. It doesn't make sense, but you know whose story is reasonable and whose story makes sense? Danessa, Christian, and Charles. Those 2 guys have no skin in this game. If Danessa had really been drunk and out of control and caused them to get into a situation with this crazy person and a gun, you guys saw Christian, he's a reasonable person. If she had caused this, he would have definitely broken up with her. But they're still together 18 months later.
Are we not telling the evidence? There's no
All
discussion
right.
about that in the trial.
Ladies and gentlemen, you'll remember the evidence as you received it and heard it. You may continue.
And speaking of 18 months, he wants you to believe, poor me. Poor me, I haven't seen my son in 18 months, and I had a protective order preventing me from doing this that I just found out about. I'm sorry. In 18 months, this woman that you claim is violent and aggressive and caused you all this trouble, prevented you from seeing your son, and you never asked why? You never investigated or spoke to a lawyer to say, hey, we have custody orders and she's preventing me from seeing my son. What can we do about this? He knew he couldn't see his son and why. All of his story is not backed by evidence. Theirs is, and you get to take it back. You'll take the photos we admitted. You'll get to take the 911 calls in which you can listen to how terrified Christian sounds and how panicked Charles sounds. None of them sound drunk. You can hear Danessa panicking in the background, not knowing where Christian is or what's wrong with him. He doesn't sound drunk. Listen to them. You can also watch the body-worn camera. All of the evidence that's been admitted, you get to bring back. He doesn't get bonus points for not shooting Christian. Because that's why we're here on aggravated assault with a deadly weapon. Because if he had struck him, we'd be here for murder. He doesn't get bonus points for being a bad shot or for Danessa possibly saving his life. As Christian said on the stand, he believes is what happened. Everyone, including David, was surprised by what happened that night. Nobody has a rational explanation because everybody was taken aback. But violent crime and violent acts are often surprising. They often don't have a rational explanation. It is time to tell David to take responsibility for his actions. The first rule of gun safety is that you do not put your finger on the trigger until you are ready to fire, and you do not point it at someone unless you are ready to shoot. He broke those rules and he broke the law. Find him guilty.
All right, ladies and gentlemen, you've heard all the evidence that you're going to hear in this case. You'll be able to go back to the jury room, pick your presiding foreperson, and then you have the court's permission to begin your deliberations. And if I could see if the jurors who will remain are Andrew. Oh, please be seated. Where did the defense go? Where did the defense go? Because,
I think they stepped outside.
all right, if you could have them come back, because Diana's gonna make sure that she has everything. And of course, either the gun goes back or the bullet goes back, but both of them can't go back. No.
Yeah.
No.
Absolutely.
All right, thank you. Just one moment.
What do y'all want to do? Because it's not more. No, I'll hold it. Okay.
There's a body in there.
Okay,
It's not-
Yeah. Then
No. Yeah.
It's just an evidence. I know, it was so funny. Zach was just like, and when he shrieked, I shrieked.
That was so bad.
I was prepared when I walked in. Yeah, I didn't see it. Dummy man on the floor of the hot chocolate.
All right, where is,
I'm gonna go
Yeah,
stick my
that was
head
cool.
out.
yes, and if you could
Actually,
see if criminal trial division, let them know that we're ready.
Are they in the back or are they just upstairs?
Yeah,
Okay.
thank you. All right, thanks.
Like that's.
Yeah, it's one of those things.
Yes,
No,
sure.
I'm so with you.
You can't have them do this together, yeah.
30 was just offered. Yeah, it's not a minute. All right, thank you. Yes. Yeah. Mhm. Oh my God. You have to show it to Norma. That is hilarious.
Yeah.
There should be down there.
On ours?
Yeah, we got ours.
What?
Our files for that.
Yes, Anna took them, so.
Probably in
Hi.
the little.
Oh.
Oh, yeah, they're probably in the other room.
All right, how's it going? Good.
Oh, there it is. I'm glad it wasn't as tight. Thank you.
They're so.
Pretty wonderful.
Oh,
I'll go first. We don't say anything. I don't know what we're gonna do. I sit in the president and said, hold on. And she- oh, I'm up. But we don't know what she's gonna do.
Right.
I feel like whatever, if they were together, or they can swap them out. I mean, I'll let you know that. Do you want to just say what you prefer going back on the recommendation? Okay. Kelly did not.
They're taking it, speaking of the six.
I just see yours.
No. They're doing it quickly, but it was. You like, I can answer.
Yeah.
What do you want? You want that?
I'll carry you on. They're really big. Come on. We'll have some downtime to read it later.
Oh, you're doing that.
It's in my car.
I was gonna tell you to read anyway.
Yeah. Yeah.
Back there.
I told you. It is, yeah.
I'll see you 1 o'clock then.
We just closed, so, yeah. Yeah. I just wondered that phrase.
Yeah. Yeah.
Like an 8, that's like the most common, like it's like 5, so she's not. Yeah, so you got all sorts of options. They're fun.
Hey, Laura. How's it going?
About the news stories, is it you have to shut people
Uh, Yeah. I'll take it. Yeah, I mean, that's.
And are we figure out about board cells? Board cells?
Get somebody.
You never know. It's like usually when you're experiencing.
Yeah, here you go. Because you'll probably need a whole. Yeah. Yes. Yeah. Some of those. I know the district. I was thinking like two of them. It's like, yeah. Yeah. We call, yeah, we in fact, we have a different.
Yeah.
All you lose is not to be.
Yeah.
Victoria.
Yes, ma'am. Yes, ma'am.
I'm just saying that they're all.
Victoria, can you sit in the?
Oh, okay.
Yeah, the gallery. Yeah.
Well, you need a real bit.
You know.
Oh, yeah.
Can you turn the camera, please? Just the camera.
I just do it myself.
They are now. Yes. Who is it? All right, if you'll hand me the file, I'll take that out. All right, thank you. Who's here on Michael Anthony Vasquez? If you approach, is your client in custody or on bond? All right, where is he?
He's not here yet.
All right, could I have, just give us a moment. The court reporter is going to take something back,
Okay.
then we'll take it up. All right, are you Tiffany Spearland? She's connecting to audio. All right, can you unmute for me, please? All right, Ms. Spearland?
Yes, ma'am.
All right, my understanding is that you've been moving around a lot.
Yes, ma'am.
So who are you currently living with now?
I am with my fiance.
All right, how long have you known him?
4 years.
And you have 2 children?
Yes, ma'am.
And who is your fiance? What's his name?
Christopher Manahan.
Christopher what?
Manahan?
Yes. Does he have any prior criminal history?
No, ma'am.
Did you research that? Or are you just taking him at his word?
I know his family and stuff. He doesn't have any criminal history.
I know a lot of people's family, and that doesn't mean that they don't have any criminal history. So my question is, did you investigate to see if he has any criminal history?
No, ma'am.
That's a problem because you have 2 children. How old are they?
21 and 16.
All right. So is the 16-year-old with you?
He's with his dad's dad in Amarillo, 2 hours away.
All right. This is what the court did. The court allowed you to transfer to Grand Prairie, Texas.
Yes.
And then you moved.
Because me and my sister, we had an altercation and I moved to Austin with my mother.
All right. And then you moved from Austin
to Lubbock. To Lubbock, where I am now. A better paying job. Me and my fiance, we're getting married in March. I'm closer to my youngest son, and it's just a better opportunity here. I'm a manager at my job. I work.
What do you do?
I'm a shift manager at McDonald's.
All right. So here's what you have to realize. You're on probation. You just can't be moving all over creation without getting permission. That's what being on probation is. You understand?
Yes, ma'am.
You are not allowed to move again without permission. Do you understand?
Yes, ma'am.
And what was the reason for you leaving your mom's home?
Just a better paying job, and I just had a grandbaby, and it's me and only my oldest son taking care of the grandbaby. So I just felt like this was a better opportunity for me to where I can be financially stable to help my son with my grandbaby and just help better myself.
All right, probation.
Yes.
She is not allowed to move again without permission. If you move again without permission, what's going to end up happening is a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
If there's some kind of emergency with your fiance, you need to let probation know. And of course, if there's an emergency, if he kicks you out or if something comes of that nature, you can leave, but you immediately need to contact your probation officer and let them know. but you are not to make another move without the court's permission unless it's an emergency. Do you understand?
Yes, ma'am.
All right. Anything else, Ms. Abrams?
That's good.
And this grandchild, are you taking care of the grandchild?
Yes, ma'am. He is with so he's in Monroe, Louisiana, but he's not with the mother. He's with a family member. So my oldest son is in college in Austin. He goes to Texas University. So I help him take care of his baby, my grandson. And
Are you
then
talking about financially?
yes, ma'am.
Okay.
And then this summer will be the first summer where my son gets to actually get him. And then we are going through the process of my son getting legally custody of him.
All right. Probation. Alternate amend her conditions to include parenting classes. All right. Do you need to speak with her?
Just ask for this contact her officer.
All right. You need to make sure you contact your probation officer. Do you understand?
Miss Smith?
Yes.
Yes.
Okay. Yes, ma'am.
All right. Good luck to you and good luck on your future marriage.
Thank you.
You're welcome. Diane, are you ready? All right, Michael Vasquez. Court is calling 2023 CR 11257, State of Texas versus Michael Anthony Vasquez. Could I have parties announced for the record? And you're on this side, counsel. For the state?
Daniel Escobar from the state of Texas.
Defense?
Catherine Valenzuela.
All right, this hearing was scheduled at 9 a.m. It is now 11:01 a.m. The defendant has not made an appearance. Defense, where's your client?
I wish I had an answer for you, Your Honor. I do not at this moment.
All right, state.
Your Honor, state would ask for a bond forfeiture.
All right, that will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
All right, thank you. All right, Norma, this is the BF. April Rodriguez. Hello. Well, you know, there's another Steelers fan in here,
There is?
right behind you, probation.
Oh, yes.
She came, she had her Steelers earrings, the scarf, everything. Sorry for the disappointment, but
Well, the Buffalo got their due, right? Whenever your fans are throwing snowballs at people, then
Yeah.
you're gonna get what you deserve.
you know what? I thought Buffalo would win, but
So did I.
I completely forgot about their past. Do you remember when they went to the Super Bowl time and time again and lost? And you're just like,
That'll never be replicated.
No.
No one will ever do that again.
no.
Those 4 years in a row.
So we've changed the way people are positioned because of security reasons. So the deputy is now asking for defense attorneys to be on this. Oh, you're in the correct place, but they're now asking for defense attorneys to be on that side. You're in the correct place.
Okay.
All right, what's happening with this case?
We have conferred, Your Honor. It is our first setting. The state has made us an offer and we are considering it at this time.
All right, how old are you?
43.
All right, Ms. Ferguson, recall this in 2 weeks for a plea deadline date, please. I always ask that question because sometimes when you're dealing with super young people, by young, I mean 18, 20, 21, they need to discuss things or they want to discuss things with their parents.
Okay.
All right, so we're going to come back on February 12th. On February 12th, you need to let the court know whether or not you're accepting the state's offer. And you were late today. Don't be late again. I understand that there was problem with rain in the garage.
Yes, sir.
All right, is there anything else, counsel?
No, Your Honor.
Thank you.
All right, you're welcome. Once you sign the reset form, you're excused.
Yes, ma'am.
Thank you.
You're welcome.
Thank you.
Juan Arambula. Good morning. All right, Mr. Arambula, you were late No, you were not late. I'm sorry. All right, on this side. Things have changed for security reasons. Defense is on this side now.
Okay, Judge.
All right, so on this case, are you all retained?
Yes, ma'am, we
Okay.
just got.
All right, if y'all can make sure that you, I don't know if you filled out the notice. Okay, awesome, because it still comes up as request denied on mine. Okay, so where are we on discovery?
Judge, I believe we have everything with the exception of a potential police report out of Laredo. I actually worked at the case for indictment and I've requested that previously. It's still not here. Additionally, I believe defense counsel wants to set an appointment to review the CAP videos in the file.
That's correct, Your Honor.
All right, so Ms. Ferguson, on this case, I'm going to give you all a reset for 30 days. That will be another discovery date, just to make sure you have everything. And then after that, state on that day, will you be prepared to make an offer?
I believe so, Your Honor.
All right.
February 26th.
All right, February 26th.
Thank you, Your Honor.
You're welcome.
Thank you for your time, sir. We know you're busy today.
Oh, thanks. Hey, just sign the reset form and your excuse.
Perfect.
Octavia Day. Hello.
Good morning,
Hi.
Judge.
Yes. Let me find this on the document. Thank you. All right, so today is plea deadline date. So, Ms. Day, are you accepting the state's offer or you're requesting a jury trial?
Rest of the trial.
Okay. How long do y'all expect the trial to last?
2
That's it.
days, maybe 3.
2 days. All right, Ms. Ferguson, need a jury trial date.
And then Judge, we have two pending motions.
Okay. If you, I don't have the motions in the file. If you have them, pull them.
I have one for a request for travel.
Okay.
Thank you. And then the other is a request for investigator funds.
Okay.
It was filed a few weeks ago.
All right. They haven't given it to me, or maybe they did and it's already been signed.
I checked it. It hasn't been signed yet. I
Okay.
could go get a copy. I
Yeah,
guess.
if you get a copy, sometime, so defense, when you all file your motions electronically, sometimes it doesn't make its way to the court. It's somewhere in the time continuum.
She's just requesting, Judge, or the request for travel. Her son lives in Conroe. She's requesting to go visit him for 3 days in February.
State doesn't object.
Okay. All right. And because she's not on GPS or anything.
She's not, Your Honor.
All right, so her traveling to different locations, unless it's with the complainant or someone, that's completely between her and her bondsman. She just needs to make sure she appears in court.
Retrial is requesting that we file a motion and get it signed by the judge.
All right, well, tell them it is done.
But I agree with you, Judge. It's not something that we needed to have done, but
All right, so they'll give you a copy of this.
thank you.
And then if you will,
Is there someone in the back that can print me that copy of the motion?
yes. All right, and then Norma, jury trial date, 2 days.
Give me 1 second. My apologies.
Okay. Okay.
That's the day I'm coming back from visiting my son.
All right, we'll put it, Norma, she's coming back that day from visiting her son, so can we put it on the 13th? Because I know it's the 12th, we'll see what goes. No, I mean, we can put her on the 13th in impact court in case they finish with everything. Yes. Is that okay? Yes.
So on the 13th at Impact Court.
Yes. And then once you bring that other motion, I will sign it.
Thank you, Judge.
Is there anything else?
That is everything.
All right, once you sign the reset form, you're excused.
Thank you.
You're welcome. Brandon Sierra. Hi. All right, so we need our jury trial date.
Good morning. Judge.
Good morning,
Yes,
how you
yes,
doing?
I'm good, thank you. Happy New Year.
Oh, Happy New Year. I always look for your travel photos. I'm like, there's one that you posted. I forget where it's from, but I placed it on my list. I no longer call it bucket list. I'm like, this is just someplace I'm gonna travel.
Yeah. No, sometimes it's more out of curiosity
Mhm.
that I want to go there. You know,
Yeah.
it's not that it's something that I wanted to do. It's like, I'm just curious. And a lot of times it's a pleasant surprise,
Oh, yeah.
you know, like when I went to Turkey, like
Mhm.
it was more a why not trip. And then I was like, what? I went several times after.
Well, you know, I think it's Richard Garcia and Denora Diaz posted something that looked as though it was an entire town carved in, I'm sure it's
Oh,
a
yeah.
historic location, carved in stone or something. It's on my list.
Yeah, no, it's amazing.
And I
Some
always tell
places.
people solo travel is great because then
Mhm.
you choose when you do something.
Yes.
All right. So state, how long is this jury trial? I think we've announced before. We've been trying to go to trial on this, but there's another trial that we're always in.
Yes, Judge, give me 1 minute.
Yes, we've had 5 trials while we've been trying to have this trial.
Yeah.
Each date, there's a different trial that's been set.
No, that just while we're waiting,
Mhm.
my client, I just want to see how you would want to handle this. They are now his business. They're also now doing commercial properties. It's
Mhm.
expanding. They're doing very well. And so he has right now, permission to work until, is it
7:30.
7:30? And so now after they finish their jobs, they do the night, you know, because it's
Mhm.
commercial, you know, at night. And so he would like to, if possible, get until 10 o'clock. So not that much longer, but just
All
to be
right.
able to work in the evenings.
State with him, I think he's been on GPS for a while now.
Okay, Judge?
Are you all okay with tracking? And he's to remain on a certain a certain area? I don't know what the area would be.
That would be reasonable, Judge, given the amount of time that he's been on GPS tracking, Judge.
All right, so if you all will prepare an area where he's not to be on, if you all want to do that by B page, you can do it by B page, and we'll just do tracking.
Okay, that will work.
Okay.
So afterwards, I'll get the B page and then have you write on it. Just, I think the last time we discussed, like, no contact near the neighborhood of the complainant, which is no problem. But okay, we'll do that. Thank you, Judge.
You're welcome. All right, Ms. Ferguson, for this, I'm sorry, how many days?
3 to 4, Judge, probably closer to 3.
All right, 3 days. Is that the when we're having that murder trial?
No, that's pretty much.
Okay.
That's work.
Let's see.
All right, so we're gonna come back on March 4th for jury trial.
Yes, Judge, I'm available. Great. Virtual.
Are you gonna be traveling? somewhere?
No, it's open. I've actually held off so that I could see, you know, so I could get these.
All right,
pieces done.
once you sign the reset form, then you both are excused.
Yes, ma'am. Thank you.
All right, you're welcome.
Okay, thank you.
Judge, the CV is at the very.
Okay. Oh, you know what? I did see this motion, and the reason why I didn't sign it is because we had no idea that that CV went with this, but okay. There you go.
Perfect. Thank you, Judge.
You're welcome. Oh, I'm sorry. Can I have the file back 1 moment? Okay, I'll have the file back. I need to write in there. Thank you.
¿Tanto Ramírez? Guadalupe Espinosa. Mr. Attorney.
Katrina Ruiz,
Morning, Your Honor.
morning. All right. All right, so this is jury trial. All right, and how much time for jury?
I would estimate about 2 days, Your Honor.
All right, Ms. Ferguson, Katrina Ruiz, jury trial, 2 days. And it's family violence.
2 days, Your Honor, but not today.
I like that.
January 29th.
All right, January 29th, you will be in impact. Once you sign the reset form, you're excused.
Thank you, Judge.
All right, thank you. And counsel, yeah, I do have that. I do have the acknowledgement of discovery.
Oh, yes. I have a question for Your Honor.
Sure.
I have an off docket travel request for you. I won't go into details yet until you allow me, but I know typically you want my client to be present as well.
Yes, and you need to confer with the state.
I've conferred with the state. I was just wondering if that was something you would be willing to hear today, even though my client is not present.
Oh, you can have her zoom in.
I can do that.
That's
as
the
well.
beauty of Zoom.
Absolutely.
Okay.
All right. Thank you,
Thanks.
Judge.
Christopher Rodriguez. Where is Christopher Rodriguez?
Your Honor.
Oh, Christopher Rodriguez, come down. All right, so where are we on discovery?
Good morning, Judge. We're still reviewing discovery. He's got 4 cases, so I'm just going through the higher offense level first and then cross-referencing with the other cases just to make sure there's nothing missing. But right now, I don't know that we're really missing anything.
Okay. All right, Ms. Ferguson, on Christopher Rodriguez, recall this in 45 days for discovery. And state, will you be prepared to make an offer in 45 days?
We will, Your Honor.
All right, thank you. All right, March 5th.
Thank you.
You're welcome.
Maybe excuse, Judge?
Yes.
Thank you.
Oh, I'm sorry. Mr. Rodriguez, do you have any questions?
No, ma'am.
All right, thank you.
I never posted it on. See, our loophole with that. Yeah.
Yeah.
Arnulfo Cervantes. All right, where are we on this case with discovery?
I think we have everything we need, Your Honor.
State, were you prepared to make an offer?
Judge, we did make it up.
Okay. All right, Mr. Cervantes, how old are you?
I'm 28.
28?
Yes, ma'am.
All right, Ms. Ferguson, if you can recall this back in 2 weeks for a plea deadline date, please. All right, we'll come back on February 12th. At that date, you need to let the court know whether or not you're accepting the state's offer. Do you understand?
Yes, sir.
Do you have any questions about anything?
Not at this time.
All right, thank you.
Thank you, Your Honor.
Thank you.
These are in the first row, second chair.
Hi, how's it going?
Good. No, this is a plea for Kevin Jones. Yeah, yeah. Is she ready? He's in the hall. Let me just grab him. No, nothing.
Approach.
Yes.
I'm here for Guadalupe Espinosa.
All right, have you conferred?
I have not been able to get in touch with Mr. Espinosa.
All right, you need to have them pull the file and we'll take it up. All right, could I have the parties on Guadalupe Espinosa?
Mr. Espinosa is not here. Okay.
Court is calling 2023 CR 10715, State of Texas versus Guadalupe Espinosa. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Keith Engel Key.
All right, this hearing was scheduled at 9 a.m. It is now 11:20 a.m. The defendant has not made an appearance. Where's your client?
I do not know. I've tried to get in touch with him. I have not been successful.
All right, state.
The judge were requesting a bond forfeiture, if that's appropriate.
All right. Can you tell me on Guadalupe Espinosa, is this a PR bond? All right, bond forfeiture will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. Jamaria Simmons.
He's in the hall, Judge, I can grab him.
All right, thank you.
Yeah, and the bunk is so confirmed in that
Okay.
room.
All right, I'll wait for them.
Your Honor, may I?
Yes.
This is regarding Katrina Ruiz. Sorry, not this. I don't want to mislead you. I actually just realized, and I apologize, I didn't mention this when you had when they said it. I'm actually not available next Monday on the 29th for a trial. My child has a doctor appointment set that day and I need to be there. There's scheduling conflicts with me and my wife and I was gonna.
Oh, we'll wait for you.
Okay.
Yeah. I'll put it in the file that you have a doctor's appointment.
Okay.
Yeah.
I might not be available. So we have a doctor's appointment. And then I have an appointment with his daycare because we're getting that set up as well. So I
Just-
may not be
just call the
available
court.
until late and like
Okay.
maybe afternoon.
All right, just
Is
let
still
us know.
okay? Because
keep
it's an
us up-
impact, that's what I was asking.
Okay. Oh, just keep us updated.
Okay, I
All
will
right.
do, Judge.
Thank you.
Oh, and then
Can I see the file on Katrina Ruiz, please? Richard Reyes. All right, Mr. Reyes, how are you doing? Not good. All right, so you know what our issues are, right? You continue to use. That's not good. And if you use, you could end up dying from that, right? So what have you been doing to try to help yourself?
Been trying to do like some research. Just like anger management and all that stuff that you've been telling me to do.
All right, well, I mean, that's good, but we got to resolve the issue of the positive for, here you go. We have to resolve the issue of you being positive
Yes,
for drugs.
I have an appointment with the TAP agency for like drug use and all that.
Mhm.
And I have yet to even talk to him about like recovery and all that.
So who are you living with?
My parents.
All right. And I'm pretty sure your parents are probably taking what you say at face value and you're probably being dishonest with them. Am I right? Because nobody goes to their loved ones and they ask them, how's your day going? I don't know anybody, unless they're so far down the rabbit hole. I don't know anybody who will say, oh, well, I just used some cocaine today. So I'm going to try to get the help that you need. I'm not trying to revoke you at this point, but you're going to have to work harder. You understand?
Yes, ma'am.
On remaining sober. So probation. Go ahead and get his TAP done. But I want to see if Lifetime Recovery is willing to accept him. And we're going to do a referral to felony drug court. And you need to let them know and be honest with them about your usage. Felony drug court is a treatment program to help you maintain your sobriety. They're going to give you the tools you need, but they can only do that if you're open and honest with them. You understand?
Yes, ma'am.
All right. So, Bashan, let's do an alternate amend for a TAP evaluation. Do a referral to felony drug court and Lifetime Recovery.
That Lifetime for outpatient services.
Well, let's see if, I'm going to see about inpatient, if they deem inpatient treatment is appropriate for him. So if they deem that inpatient treatment is appropriate, you're going to be an inpatient, okay?
Better than prison.
Oh, it is, because
I
what
appreciate that.
you're looking at 20 years potentially. It's better than prison and it's better than potentially your parents having to identify your body, because that happens. And I'm going to want 90 sober meetings in 90 days.
Yes, Judge. Another issue that we're, not necessarily an issue, but a subject that we are trying to get clarification on, or direction from the court is the restitution, Judge.
Oh yeah, the money. I was gonna start making payments because I started a couple projects and I should be able to start paying off the delinquent. Oh, because I know it's up to like almost $500.
All right, what's the issue with restitution probation?
Your Honor, we just want to close out the matter of restitution. From my understanding, and from the supplemental report, the other party in the case, they're not looking for any restitution.
Okay.
And I did speak with the state and they don't have any notes or anything in regards to restitution.
All right, then we'll close out the restitution.
Your Honor, last time we talked, remember when you were saying that the restitution, you know, like if I had injured them and all that stuff, like but like I was trying to tell you that I didn't really do anything to them, and like I swear, like I really do, because I know I waived my trial away, but I don't know if there's any way.
All right, so let me just explain something to you. And what I'm telling you, I used to always tell my clients this. Now, number one, they're saying that there is no restitution amount, so there's not going to be restitution. But number two, you know what your trust level is right now?
0.
No. And I would tell my clients this all the time. It's not 0, it's less than 0. And because you've been living your life where you've been using and you've been dishonest, I'm sure with your parents, you never tell anybody, hey, I'm going out to use. So you have to build up your trust level now. Everything that you do has to be documented because people are going to question it. Do you understand? So we're going to close out the matter of restitution, but you're going to do the TAP evaluation. You're going to be referred to felony drug court. Make sure you do not miss that appointment. You understand?
So,
All right. Is there anything else?
no, Your Honor,
All right. Do better.
appreciate it.
You're welcome. So did we have a question or?
No, Your Honor, they were having difficulties with the computers that they use.
Oh, okay. All right. Whenever you all are ready on something, let the court know.
Can I ask you a question?
Sure.
About something? When on a DWI for when someone's required to do 10 days in the jail or the state's asking for it outside the agreement, is there some other alternatives that you would consider?
GPS.
Okay.
And depending if they want GPS for work, then it will be 30 days. But if they just,
Want to stay home for 10 days?
yeah, 10
Okay.
days.
Okay, awesome. Thank you.
You're welcome. All right. Are the parties ready on Kevin Jones? Diana, I realized how little water I've been drinking. So now I need to get to 11 very quickly because I'm not even at
We
11.
can wait.
Norma, if you all could go ahead and order lunch. Okay. Just one moment. Deputy Laura. Norman. Or either across the street. I think that may be simpler. All right, court is calling 2023 CR 5280 State of Texas versus Kevin Alfred James Jones. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Lindsay Shaw for Mr. Jones.
And are you Mr. Jones?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. The attorney listed on the appointment is Charles Bach.
Yes, Your Honor. I'm an associate with Mr. Bunk. Mr. Jones is aware of that. Mr. Bunk is here present today, has conferred with Mr. Jones, but I'm
All right,
taking-
do you have any objection to her standing in? No. All right, thank
We're all one happy family.
you. Okay. All right, and everyone else, please make sure you whisper. We are on the record. Mr. Jones, I'm going to show you what's entitled Application for Deferred Adjudication, Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes.
You're going to need to speak up so the court reporter can hear. Showing you the true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Count one, proceeding on count two, and then has enhancement.
Any objection?
No, Your Honor.
Showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Off the record for a moment. Probation, this is an application. We're back on the record. Did you understand in count two, you're charged with the offense of possession of a controlled substance, penalty group 1, 4,200 grams? Oh, off the record for a moment. I thought y'all were waiving the enhancement. Oh, but you guys were going on count two, which is a possession. Okay, and then, okay, so you're not waiving the repeater.
Correct. Not-
Okay.
Sorry.
Yes.
I said it, yeah.
All right, thanks.
Yeah, sorry, Judge.
All right, I was wondering,
Yeah.
am I wrong? Okay. So that you understand that the state is not waiving the enhancement paragraph. Do you understand that? And defense, is that correct?
Yes, Your Honor.
All right, so what's being waived is count one only, correct?
That is correct.
Yes,
All
ma'am.
right, any objection to the waiver of count one?
No objection.
All right, so what you're charged with in count two is possession of a controlled substance penalty group 1, 4 grams to 200 grams. That's a second degree felony. The range of punishment for a second degree felony is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the state is able to prove the enhancement paragraph allegation, then your range of punishment will be anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Off the record. So everyone, please don't approach up here when we're on the record. Yes.
I'm
Yes.
waiting for him.
No. Nobody see that sign?
Oh.
Okay, thank you. All right, we're back on the record. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Jones, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Going to show you what the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, the state is proceeding on count 2. You'd agree that you've been previously convicted of 1 or more felonies. Punishment is to be assessed at 9 years in the prison. There's a $2,500 fine. There's no application for deferred adjudication. The state recommends community supervision. They're taking in consideration 2023 CR 4278, and there's to be restitution to SAPD for drug testing. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be for a term of 6 years. There'll be a TAP evaluation and 220 hours community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense as charged in count 2, how do you plea? Guilty, not guilty, or no contest? And to the enhancement paragraph, how do you plead? True or not true? State any evidence to support the defendant's plea?
State exhibit number 1 with all its attachments.
No objection.
And state you may continue to confer.
Thank you.
Mr. Jones, I'm going to show you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. I'll go back. Oh, no, I'm sorry, one more thing, I forgot to ask that. Okay, that's fine. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement paragraph true based upon your plea of true and based upon states exhibits 1 and attachments.
Thank
Are
you.
you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right. Are you employed? That's either yes or no.
No.
All right. How long have you been unemployed?
Actual 9 to 5. I'm not even sure. I do side jobs. In the company.
All right. If you are on probation in this court, I require a job, and I require a job where someone gives you a W-2. You understand?
Well, I'll have my own W-2 soon. I move the company.
You need to provide proof of that. Do you have any children?
Yes.
How many? What are their ages?
4 and 1 on the way.
Who do you live with?
I don't want my.
If you're drug tested today, what are the results going to be? For everything, and that includes marijuana, alcohol, all of that.
I feel a little dirty.
Have you ever used anything other than marijuana? That's either yes or no. We're not doing notes. We're not doing all of this, and I don't understand. I'm getting some attitude from you, and I don't understand that. If you want to wear a Michael Jordan jersey, Michael Jordan could afford to have attitude because he was exhibiting greatness. You are not. So there's to be no attitude towards me in this court. Do you understand? And you will get a job. Do you understand? Am I speaking a foreign language to you? All right, then you need to answer my question. Do you understand that you will get a job?
Should I do that job?
All right, so this is what we're gonna do. You're gonna step back, you'll wait, I'll take up sentencing later. And counsel, if you want to speak to your client about
Yes,
his
ma'am.
attitude.
Yes, ma'am.
Thank you. All right, who's here on Carl Jones?
Actually, that's the city attorney, but it might be Kelly McGinnis.
All right,
Who was who?
all right, I'll wait for them.
Step in the hall as your client, Judge.
Okay, thank you. Who's here on Rudolph Montoya? All right, and we're just here to get a date for jury trial. All right, when Ms. Ferguson,
April 9th.
April 9th?
Yes.
Okay. And you'll be able to get in touch with your client and let them know?
Absolutely, Judge.
All right, so we'll be back on April 9th for jury trial. Is there anything else?
No.
All right, thanks.
Thanks, Judge.
Yes.
We filled out the pay page, so we just want to make sure it was.
Oh, I've signed it.
You did, okay.
Yes, and if you'll ask them,
Add anything more or anything.
no, and if you ask them, they'll make a copy for you, or either you can make a copy in the back.
Thank you so much.
You're welcome.
Thank you. It's random, see that. Yeah,
May I approach, Your Honor?
Hello,
May I
yes,
approach?
yes.
A client informed me he should be logging on soon, so whenever the court is ready, that is the motion.
Okay. And did you speak with the state to see if they have any objections?
I did, well, I spoke with Mr. Escobar. He informed me, want me to tell you what he informed me?
Sure.
He informed me that the state doesn't object. They are requesting a drug test upon return. Okay, I don't think we won't have any issue with that.
Okay, all right, as soon as they log in, we'll take it up.
Thank you.
Amethyst Salas? All right, so where are we on this? Discovery?
Well, Judge, just to let you know, I think we're at an agreement. However, we do not have a judgment from the out of county. It's from Karnes County. I'm gonna order that. All we have is TCIC.
All right, if they're accepting of TCIC, I know there are some legal issues with that.
And I'm fine with that, Judge. I just didn't know if the court would allow that, but if they want to do that, I'm fine with doing it today too.
Okay.
He's okay with going forward with that, Judge.
Judge, I'll get the paperwork done right away.
All right, could you mute us for one moment, please? Oh, this is, oh, you. Guillaume Hernandez? Hello.
How you doing, man?
All right, how are you doing?
I'm doing great. How about yourself?
Oh, I'm doing great. It's Monday, new things can always happen. So where are we on discovery?
I have to review it. I just met Mr. Guion Hernandez and discovered he has an immigration hold and
Okay.
has an immigration issue that I need to look into. I have conferred, but I would like to have a reset to see if I could resolve the case, given his immigration hold.
All right, Ms. Ferguson, we're gonna need an immigration attorney appointed on this case. And that immigration attorney is strictly to assist your counsel if he needs it, how this case will impact your immigration status, but they are not your immigration attorney for all of your issues. You understand?
Yes, ma'am.
All right. So Ms. Ferguson, on this, if you can recall it in 45 days. All right. We'll be back on March 5th.
Okay.
Is there anything else?
Nothing further, Your Honor.
Okay.
So I'll see you on that.
Please have a seat, sir.
Thank you, ma'am. Thank you, Ms. Honor. Thank you.
You're welcome. Thank you. This is done. And this is going to be a plea. Mario Quintanilla. And Mr. Quintanilla, if you can unmute and start video.
Hello?
Hello, and you need to remove your hat.
Oh, see, sorry, my hair's all messed up.
Oh, no problem. So your attorney has submitted a permission for you to travel.
Yes,
So
yes.
what are you doing in Lincoln, Nebraska?
Well, in Lincoln, Nebraska, I'm in a band and we were going to travel up there to go on this little run that we were going to Nebraska to play a couple shows up there. And January 25th, we were going to be getting there to play a show and then stay the night. I have all the information where we're going to stay. Here, let me
Right.
go.
And what do you play an instrument?
Yes, ma'am.
What do you play?
I play the bass guitar.
Okay. All right. The state doesn't have any objections.
I spoke with Mr. Escobar, Your Honor. Oh, he's not in the courtroom at this time, but he said no objection so long as the court was willing to require a UA upon return.
All right. You're going to have to do a UA upon return. So don't smoke any marijuana.
Okay, for sure. What is a UA? What is that?
That's where you do a urine test and they
Oh,
let
okay,
you know
okay.
whether or not you did drugs while you were away.
Okay, for sure.
All right.
So on the way, so I will be doing it when I get back or before?
Yes, when you come back.
Okay, I see what you're saying.
All right. Is there anything else?
Um,
All right, then you are excused.
oh, thank you very much.
All right, you're welcome.
Thank you, Judge.
You're welcome.
Do you want me to take that to the back for you or?
Yes.
So was I good?
Oh, yes, you can be excused.
Okay, well, thank you.
Hello.
Do we need to finish with Mr. Jones?
Can you mute us, please? Jones? And probation, this is an application. Well, just one moment. Yes, this is an application. Court is calling 2023 CR 3509, State of Texas versus Carl Edward Jones. Could I have parties announced for the record for the state defense?
Charles Barr.
Are you Mr. Jones?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Jones, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, we are including the.
All right. Mr. Jones, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If the state proves the enhancement allegation, then the range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Sorry, Judge.
Yes.
Did we put that, did we include the enhancement or? are we just
Yes.
proceeding? Okay, but it'd be 2 to 20?
Yes.
Okay, just making sure.
Okay.
Thank you.
All right, I'm going to show you what's entitled Court Admonishments. I previously shown you that. Did you review the plea bargain paragraph with your attorney? Did you understand it?
Yes, ma'am, I did.
Court doesn't have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you are giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
I think that's Anna's. Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Absolutely.
Mr. Jones, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, you agree that you've been previously convicted of one or more felonies for enhancement. Punishment is to be assessed at 10 years in the prison. There's a $2,500 fine. State recommends community supervision, and there should be ignition interlock for the full term. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes.
State, is that the plea?
Yes, it is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Oh, Judge.
Next, I'm showing you outside the agreement. The state is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 10 days in the Bexar County Jail, 200 hours of community service restitution, and 2-year license suspension. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
And to the enhancement paragraph, how do you plead? True or not true?
True.
State any evidence to support the defendant's plea.
Yes, Your Honor. State exhibit number 1 with all this attachment.
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true. Are we proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We believe he's worthy of the plea bargain. We ask you to follow it. I would like to address the 10 days in jail and the fine at the appropriate time.
All right. So with regards to the fine,
I would I would ask if you would consider probating his fine, where he's gonna have the interlock ignition for the entire length of his probation. As you are aware, there are lots of, when you're on probation for 10 years, there's a lot of expenses incurred as part of that. So we're asking you to consider probating his fine.
All right. And Mr. Jones, will you be able to pay the court costs in this case if you're set up on an installment plan?
Yes, ma'am.
All right. What are the court costs going to be, please? All right. And while she's looking in that, and you wanted to address the 10 days in the Bexar County Jail?
Yes, Judge, we'd like to see, he is fully employed. We'd like to see if he could serve that on GPS rather than in jail.
All right. Because of issues at the jail, I do allow people to serve that on GPS. Here's your choices with regards to that. You can either do 10 days, full house arrest at your home on GPS for a full 10 days, which means you will not be working. Or either if you want to work, then it's going to be 30 days GPS.
Yes, ma'am.
So which,
30, yeah.
all right. All right, court costs in this case will be $425. So if they set up an installment payment plan for you, will you be able to pay that?
Yes, ma'am.
All right. So what do you do for a living?
I work for a printing company. I've been there 37 years.
Okay. And when you say printing, what does that mean?
We do printing like stationery, letterheads.
Okay.
Envelopes, business cards,
All right. So when are you off from work?
the weekends.
So what do you do in your spare time on the weekends?
I'm just usually at home. Playing video games, really.
All right. What video games do you play?
Like Xbox, stuff like that.
I mean, what's the game? Final Fantasy?
Oh, no.
Mortal
it's like,
Kombat?
no, it's like World War II,
Ah,
stuff
okay.
like that. Yeah.
All right. I'm always interested because I play video games as
Yeah.
well. All right. $2,500 fine will be probated. As previously stated, the enhancement paragraph is true. I'm finding you guilty. I'm going to sentence you to 10 years in prison, suspended and probated for 10 years, 2 years driver's license suspension. I'm going to want a TAP evaluation. I'm going to want a referral to felony drug court. There is to be ignition interlock full term. Victim impact panel live. DWI education. $200 hours of community service restitution. I'm going to want 90 sober meetings in 90 days. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. And probation, just make sure the UAs doesn't interfere with his employment. They'll work with you to do that over your lunch break or something. If something happens where it's interfering with your employment, just let your probation officer know, or you can come back in the court and let me know. I don't want you to lose your job.
Yes, ma'am.
Field visits. 1 time per month for 3 months. Probation, is there anything else?
No, sir.
All right. Is there anything else you need from the court to be successful?
No. You said,
I'm sorry, you for his 30 days BPS,
Yes,
that's partial.
for work. Thank you. So on the 30 days, you'll only be allowed to go to work. So you can't do other things. It's just work. You understand?
Yes, ma'am.
did you send his probation fees at the minimum?
No,
Okay.
because probation fees, actually, the way they have it worked out, probation fees actually helps pay probation officers. Yeah. So I try not to lower that. but I am probating your fine. So if you complete everything, you won't have to pay the $2,500 fine.
Yes, ma'am. Thank you.
Anything else, probation? All right, anything else you need from the court to be successful?
No, ma'am. Thank you so much.
You're welcome. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. When people drink alcohol, they never go out drinking saying, oh, I'm going to go drink and let me go kill somebody. You are one of those people who cannot drink alcohol at all. You understand?
Yes, ma'am.
So while you're on this probation, you're not allowed to drink alcohol. And if you successfully complete this probation, don't go celebrating. You are one of the people who can't drink alcohol at all. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
You're welcome. All right. Are we ready on Mr. Jones?
Judge.
That's it.
See, front row. This young lady in the front.
All right, we're back on the record in 2023 CR 5280, State of Texas versus Kevin Jones for defense
Charles Bach.
and state.
Jason Gary.
All right. This is what the court is going to do. The court is going to sentence you to 9 years in prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person. There's to be regular UAs, and he needs to be tested for levels. There's a $2,500 fine. That'll be probated. What are the court costs in this case, please? Take in consideration 2023 CR 4278. There's to be restitution to SAPD for drug testing. I'm going to want field visits 1 time per month until further notice. 220 hours of community service restitution. I'm going to ask for parenting classes. Once he completes that, the community service hours will be deemed satisfied. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. What's the cost? All right, the court costs in this case are $325. Will you be able to pay that in installments?
Yes.
Probation, is there anything else he needs? Is there anything else you need from the court to be successful? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right.
Did you,
Yes.
sorry, did you say 9 years probated for 8?
Yes. All right. If he completes everything successfully, then he can always come back.
Yes, Judge.
All right. Thank you.
Thank you. May we be excused?
Yes. Who's here on Jamara Simmons?
We're conferring in the back, Judge.
Okay. Jorge Sandoval.
I'm present for him, Judge. He's present.
Okay.
On that, Judge, I'm asking to see if we can recall him for Friday.
All right. Can I see Mr. Sandoval? Is there a reason for this recall?
He's hoping to have a future with the city. And so I conferred with the state. And I want to check with the city to make sure. I want him to check with the city, and I want to check with the city to see if that's going to be a possibility down the road.
All right, Ms. Ferguson, on this case, can we recall this for Monday? All right, we'll come back on Monday. Is that enough time for you, or do you need more?
I think that should be fine.
All right, we will see you back on Monday.
Thank you, Judge.
You're welcome. Diana, as soon as our lunch arrives, we'll break.
Thank you, Judge.
You're welcome. Have a good one. All right, who's here on Joe Anthony Vasquez?
Present, ready, Judge.
All right. Is there an application in this case?
No, Judge.
Okay. Probation, there's no application. Court is calling 2023 CR 9851, State of Texas versus Joe Anthony Vasquez. Can I have parties announced for the record for the state? Defense?
Robert here, Your Honor, for defendant Joe Anthony Vasquez, and we're ready.
All right, and are you Joe Anthony Vasquez?
Yes, Your Honor.
Counsel, have you received all the discovery? Did you review that with your client?
We did, Judge.
Court will find that the state is in compliance with discovery. Mr. Vasquez, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Are you proceeding on the enhancement allegation?
Yes, Your Honor.
All right. Mr. Vasquez, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of assault family second offense? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
All right, off the record for a moment, please. Could you mute us? To go on one. All right, we're going to go back on the record. I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge, we do.
All right, it's my understanding that off the record, there was a discussion and states you're proceeding on paragraph 2 of the enhancement. Is that correct?
Yes, Your Honor.
All right. So I'm going to show you what's entitled assault family second. I'm sorry, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
All right, did you understand you're charged with assault family second offense? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the state is able to prove up the enhancement allegation, then your range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to keep those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe that he is, and he was, Judge.
Mr. Vasquez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, you agree that you've been previously convicted of one or more felonies for enhancement. Punishments be assessed at 6 years in the prison. There are no applications. The state is taking in consideration 2023 CR 9852. There's an affirmative finding of family violence. There's to be no harmful or injurious contact with Brittany Jimenez. All right, off the record. So parties know, unless Brittany Jimenez is here to state that she wants to have contact with him, the court is not inclined to follow that portion of the agreement. So is that going to be a deal breaker?
I don't think it'd be a deal breaker, Judge. Just to inform the court, she did sign a affidavit of non-prosecution in these matters.
All right, if y'all want to remove that in the initial.
Absolutely, Judge. So
What does that mean?
you can't contact Brittany while you're in jail.
Oh.
I just put NCO, Judge. That'd be okay with you?
I'm sorry?
NCO? Oh,
Yes,
contact
that's fine.
Yeah.
Thank you. All right, and there's to be no contact with Brittany Jimenez. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
And did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of your plea?
Yes, Your Honor.
Defense, is that the plea?
That is, Judge.
State, is that the plea?
Yes, Your Honor.
I'm going to show you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contents.
And to the enhancement paragraph, paragraph 2, how do you plead? True or not true?
Excuse me?
The enhancement paragraph that's in the indictment, how do you plead to that? True or not true?
True.
Right. State any evidence to support the defendant's plea.
Yes, Your Honor. State offer states 1 and attachments.
Defense is reviewed, Judge. We have no objections.
Mr. Vasquez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes.
Did you understand, again, that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty, and the court will find the enhancement true based upon your plea of true. Are you proceeding with sentencing?
We're ready for sentencing.
Anything you wish to say on behalf of your client?
No, Judge.
All right, the court will follow your agreement, find you guilty, find the enhancement true. That's paragraph 2. Sentence you to 6 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Brittany Jimenez. Take in consideration 2023 CR 9852. Is there anything else with regards to sentencing?
Nothing further from the state, Your Honor.
Nothing further from defense, Your Honor.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Obviously, you have anger issues. You're one of those people who, you know, I told the last gentleman he shouldn't drink alcohol.
Yeah,
You shouldn't be in a relationship.
yeah, I know.
Yeah, I mean, you say
There's
you
always
know.
two sides to it, though.
Well, I mean, the problem is you say there's two sides to every story, but you can't go to somebody's house, break in a window, and then having them get in the car with you and threatening to damage the car with a crowbar if they do not. And you have other assault family cases. And I don't know why, but, well, I do know why. I know that, well, I should say, I know the different reasons why people stay in relationships that are abusive. But the fact that this person even continues to want to have contact with you, not happening. You need to move on. And you need to take care of your anger issues. So this is what you need to do. When you go to prison, do not be thinking about women. Do not be thinking about a relationship. You need to sit down and ask yourself how you got in the position you're in. And then when you're released from prison, because at some point you're going to be released, go get an orchid. They sell them throughout the year. That orchid is going to come with blooms on it. Once the bloom falls off and you're able to get that orchid to rebloom, you may be ready for a relationship. You understand?
All right.
And if you come back for this, you know what your minimum is going to be in a case? 25 years. That's where you're going to be starting at because you're going to be a habitual. You understand?
Yes, Your Honor.
All right. Good luck to you.
All right, thank you.
All right. Do you have the dismissal?
I do, Your Honor. Yes.
Okay. Thank you.
Yeah, thank you.
All right. Who's the person in the back swaying from side to side? Okay. Diana, I'm at 11:01 on the water. So I gotta get to 1 p.m. I am an hour. And you know, if I get to the 1 p.m., it's gonna be feeling great. That's what it says, feeling great. Mm-hmm. Yes.
And thank you again for kind of walking me through the.
Oh, no problem. I'm telling you, it happens. But once you have,
Yes. Thank you, ma'am.
once
Thank
you done enough, it will just be like second nature, but it's still not going to be second nature to the state jail felonies.
Oh, yeah, when they pull out the code.
Oh, yes, because that one you have to pull out the code.
Absolutely. Yes, you do. Well, hey, have a good rest of your week. Yeah, absolutely. We'll catch you around.
Yeah, he said it, or Judge said April 9th. April 9th, yes.
you're welcome. All right, could I see the file on Jeremy Tapia, please? Yes. Jeremy Michael Tapia. All right, is he on a commercial bond? All right, could you let Kimberly Gonzalez know that her client is not here? All right, could I see a prosecutor, please? Court is calling 2021 CR 0667, State of Texas versus Jeremy Michael Tapia. Could I have the state announced for the record, please?
Jason Garahan, Your Honor.
All right, this hearing was scheduled at 9 a.m. It is now 12:26 p.m. The defendant has not made an appearance. State?
State's requesting a bond forfeiture, Your Honor.
All right, that will be granted and he will be remanded without bond. If he makes an appearance, the court will reconsider. Thank you.
Thank you, Judge.
Okay.
It was a.
Does anyone have Kimberly Gonzalez's cell number? I used to have it. Could you text her and let her know that Jeremy Michael Tapia did not appear? So Norma, the people we have left is, we'll take this up. Amethyst Solace and probation. This is an application.
Yes, sir.
All right, the court is calling 2023 CR 10786, State of Texas versus Amethyst Rose. What's the Richard? Ricarda Salas. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Will Brooks for the defendant, Judge.
All right, and are you Miss Salas? Counsel, have you received all the discovery? Did you review it with your client?
Yes and yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Salas, I'm showing you what's entitled application for community supervision or deferred adjudication. Did you review that with your attorney? Did you understand it? Next, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you weigh the reading of the indictment?
Yes, we do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Excuse me, is somebody doing a selfie in the back of the room? Okay, no problem. All right, we're back on the record. Did you understand you're charged with felon in possession of a firearm? The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Is she applying for deferred or no?
No, Judge, she's
Okay.
straight probation.
Right. Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Judge.
Ms. Salas, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishments be assessed at 2 years in the prison. You are to agree that you've been previously convicted of one or more felonies. There is a $500 fine and the state recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State? Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No motions, Judge.
Next, I'm showing you outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 120 hours community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence? Yeah.
State exhibit number one with opposite statements for.
No objections to states one or attachments.
All right, I apologize. I did a slow roll out of that question. All right, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Do you also plead true to the fact that on the 14th day of August AD 2019 and cause number CRW 1808141 in the 81st District Court of Karnes County, Texas, that you were convicted of an offense in that cause number?
Yes, ma'am.
All right, is that true?
Yes, ma'am.
All right. Court will review states exhibits 1 and attachments. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We'll waive a pre-sentencing investigation, Judge.
All right, anything you wish to say on behalf of your client?
Judge, first and foremost, that Mr. Gahan is very compassionate to offer her probation. Her circumstances were that she was homeless at the time, that she was living in her mom's vehicle and had the firearm for protection. She does know she can't own or possess firearms, Judge. But she has her life together right now, Judge. She's living with her mom, who's back then her dad. She's got a job. And I think she'll be successful on probation. I would ask the court to consider ordering her to complete her GED and maybe giving her some credit for some community service hours because she has not attained that level of education yet, Judge.
All right. So what do you do for work?
I'm a cashier.
Okay. And do you have any children?
No, ma'am.
And if you're drug tested today, what are the results going to be?
I'll be negative.
All right. And can you give me the court costs in this case, please?
Yeah.
All right, thank you. All right. The court costs in this case are going to be $325. Will you be able to pay that in installments?
Yes.
All right. So the court is going to sentence you to 2 years in the prison, suspended and probated for 4 years. There's a $500 fine that will be probated. Proof of employment within 30 days. There should be no employment as a home health care provider with minors. Regular reporting by Zoom or in person. Random regular UAs. We can do a TAP evaluation out of custody. If the TAP recommends inpatient treatment, we'll start with outpatient treatment. Field visits 1 time per month for 3 months. Then at probation's discretion. There's to be 120 hours of community service restitution. That will be waived if you complete your GED or either obtained some type of certificate from a trade school. You understand? And the reason why I'm doing that, because sometimes people find the job they like and that's the job they like, and that is fine. Because I always tell people we need cashiers, we need people to bring in crops, we need all these different people. But I don't want you to be at a job because you don't have qualifications to do something else if you want to. You understand?
Yes, ma'am.
So if you complete, I'm not going to order her to get her GED. I'm not going to order her to go to trade school. But if you get your GED or get a certificate from a trade school, then the 120 hours of community service restitution will be waived. And it's always great to have, you're improving yourself and that counting for community service. You understand?
Yes, ma'am.
All right. Probation, is there anything else she needs? Is there anything else you need from the court to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so we can go off the record. You're living with your mom. How old are you?
27.
All right, you're 27. I have to tell everybody this, whatever age you are, even if you're 50, if you're living with your mom, you got to follow mom's rules. So if your mom has a curfew for you, even though you consider yourself an adult, you're going to have to follow her rules. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
Thank you. All right, Diana, we're going to go ahead and take our break because no one else is ready. So we're going to take our lunch break